I welcome Professor Sundra Rajoo, former Director, Asian International Arbitration Center. I welcome Mr. Ritin Rai, Senior Advocate of Supreme Court of India. And I also welcome Ms. Shaneen Parikh, Senior Partner of Amarchand Mangaldas. So definitely your words and your discussion will be beneficial for my students. Once again, I welcome you, and I also welcome all the participants who are here in this webinar. And during this lockdown and pandemic situation, I think this is only the platform by which we can interact with each other. So thank you so much once again on behalf of Manipal University, Jaipur. Thank you, sir.
Thank you. Thank you, Dr. Sharma, and welcome to everyone, and most of all my panelists who've agreed to give their time today. We're actually quite excited to be doing this session because it's nice to pass on whatever experience or knowledge that we have to you. So we're going to keep it short, and we're going to keep it sweet, and we're going to make sure that you have a chance to ask some questions at the end. So today's theme for discussion is efficiency and innovation in arbitration. And it is a very timely topic, particularly for India. We've come a long way in the last decade. We've witnessed significant changes in the way that arbitration is practiced. Across the world also, there have been various innovative rules and practices that have become the norm. And the reason for this is a bit to be cost and time efficient, as also providing a robust adjudication process. Our default ad hoc procedure had not really kept place with that, but our government and our judiciary, having realized it, the recent amendments in 2015 and 2019 have really helped streamline the process. Of course, the intent of the government has been to make India, and I quote, a robust center for international and domestic arbitration. And we will now be dealing with some topics that will aid in the efficiency of an arbitration, and also some innovations that have been made in practice and to the rules of various arbitral institutions that, in a sense, further this purpose. So I'm going to first move to Ritin, will be my first question. And that is, as I just mentioned, our default Indian procedure has been ad hoc. The Justice Sri Krishna's report was a big push for institutional arbitration. So, what do you think are the key differences between ad hoc and institutional arbitration? What do you think works best, and when would you choose one over the other?
Thank you, Shaneen. Thank you. And like you, I think I'm quite excited to be part of this webinar. It's, like you said, interesting to share some of our learning, but also with younger students, it's also interesting to get their perspectives, which are sometimes not colored by too much practical experience. I'm looking forward to a nice discussion even towards the end of this session. I think in terms of ad hoc, I think let's just start by understanding what that word means. Obviously it's a Latin phrase, which is to this, but ad hoc, when we talk of it in the context of arbitration, ad hoc arbitration, it's really something created for a particular purpose. So an ad hoc arbitration is created by the parties for the purpose of adjudicating their particular dispute. And I think that is somewhere where the problem itself lies, because when the parties are entering into an arbitration agreement, they have a common purpose. They seem to agree on everything when they're entering into an agreement, because of course they're entering into an agreement. And so they also enter into an arbitration agreement, which has an ad hoc tribunal, which is a tribunal to be constituted by themselves and not with reference to a particular institution. But that ad hoc arrangement in trouble, the arbitration starts and parties have different agendas. So unlike when they actually entered into the agreement and they were all ad item on the same page, now when the arbitration starts, they actually are in adversarial positions. And because they're in adversarial positions, it becomes hard, I think, in a normal ad hoc arbitration for the tribunal to impose its will on the parties. And that's where I think an institutional arbitration stands out as a much better and more efficient way to resolve a dispute, because you're bound by the rules of that institution, as opposed to an ad hoc tribunal, which has to make up its own rules and often does so by consent of the parties. So, in the context of, I think, Indian arbitrations, what I have in mind is, uh, when we had ad hoc arbitrations, it was much easier to seek adjournments from the tribunal because the tribunal would be more accommodating. They were appointed by the parties, and they were not bound by a set of institutional rules. They felt, I think, that they had more play in the joints. They could grant adjournments or longer dates. They would be more liberal with, let's say, amendment of pleadings. And let's talk about, COVID and my experience, at least in the last 2 months. I have done two hearings in arbitrations where it was an institutional arbitration, and the tribunal required us to participate in those. And equally, I've had three ad hoc arbitration hearings adjourned because the opposite party simply said, we are uncomfortable with the platform. We are unable to prepare in advance of this hearing. In these days of lockdown, we simply cannot. And I think an ad hoc tribunal found it harder to push back on that kind of party request. So the advantage of an institutional arbitration is parties have agreed upfront to be bound by a set of institutional rules. And I think the other advantage of an arbitration agreement that has an institutional arbitration is that the institutional rules also keep changing and adopt best practices from other institutions and adopt better practices more conversant with the particular times. That's why even in India, I think now, as Shaneen also said, you're seeing in our Arbitration Act also a push towards institutional arbitration. And historically, I think we've seen this push or this nudge, at least in the Delhi High Court, I can say, even in ad hoc arbitrations, judges would often nudge us towards the Delhi International Arbitration Center, which is partly set up by the Delhi High Court, but they would nudge us towards that institution. That was a more informal process. Now, in the Arbitration Act, you see the power of appointment of an arbitrator being sent to an institution which has to be nominated by the court. So although this provision in Section 11 hasn't yet been notified, the idea is to move perhaps towards institutional arbitrations. And also another provision that has not yet been brought into force is the Arbitration Council of India that will in some senses monitor or look at the performance of arbitral institutions and arbitrators itself. So I think, Shaneen, the move towards institutional arbitration is a move that's happening in India, and it's accelerating to some extent. And institutional arbitration has this big advantage of perhaps being able to draw best practices from other institutions. And so if you look at any institutional rules, you will see through the years, the rules themselves get amended or updated to reflect what the institution is trying to deliver, which ultimately, as Shaneen said, is a cost-effective, time-effective, robust dispute resolution process. And the institution is constantly mindful that it has to apply its mind and its rules to what is the best way to achieve those outcomes. So, historically, if you look at, like I said, ICC rules, you'll see amendments made to case management, to expedited procedure, to virtual hearings. And even in the context of COVID, I think many institutions have actually set out guidelines which try to address the challenges faced by parties in this COVID environment. So, for example, the ICC has brought in rules to try and support virtual hearings, guidelines to arbitrators to try and parcel out parts of a dispute and at least decide those disputes that they can over a virtual hearing, try and have recourse to, let's say, partial awards, delivery by electronic means. So I think if you look at institutions, they are able more quickly to adapt and therefore serve the objective of a cost-effective, timely robust, as Shaneen's word, robust dispute resolution system, whereas an ad hoc arbitrator or an arbitral tribunal finds it by definition itself a little harder to do. So that's what I would just broadly describe, Shaneen, as you know, where ad hoc and institutional fit in, what's been happening in India, and to some extent even among the international institutions.
Okay. Thanks, Ritin. You used the word cost effective. Now, a lot of people and a lot of clients actually ask me that isn't institutional arbitration much more expensive? Won't ad hoc procedure be more cost effective? So what are your thoughts on that?
I think whenever I have tried to look at the numbers, I don't see this as a real as a fair question. I think if you look at ad hoc arbitrations, the first issue, of course, for a client is the fees are completely uncertain at the outset, because you cannot tell the client whether you're going to have 5 hearings or even 50. And I don't mean 50 as an exaggeration. I mean, there are arbitrations that have those kinds of Shani, this is a problem in the past, and frankly, I think still continues to some extent. Ad hoc arbitrations also charge a reading fee, a fee for drafting an award. Against that, if you contrast with an institution, you at least have certainty. In the first instance, you have clarity and certainty regarding what the fee will be. And maybe it's because you have that clarity and certainty that people say, oh my God, that looks like a high number. But actually, if you would look at ad hoc arbitrations and arbitrators, I'm talking about high value disputes, I think at the end of an arbitration, a client would find that possibly the institutional arbitrations are at least as cost effective. And let's take just one small example is of transcription of evidence. I mean, I think all of us have sat in domestic arbitrations where evidence is recorded by the counsel first asking a question, the arbitrators amending it, the witness answering the question, the arbitrators changing that answer. I mean, think of the time that is saved by just a simple thing like transcription. And so when you have an institutional arbitration, you're more likely to have those kinds of things also. So I think that the criticism that institutional arbitration is more expensive, I don't know whether this is just anecdotal or whether empirically actually it bears out in most of the cases.
So I couldn't agree with you more, Ritin, actually. And I have seen several cases in exactly because of what you said, the number of hearings and the rather lengthy procedure in taking evidence, that an ad hoc arbitration has actually become way more expensive than institutional. So thanks for that. So Sarosh, my next question actually is to you. And I am going to take off from the ad hoc and institutional procedure and ask you about court supervision. What is the extent of supervisory jurisdiction that you have seen courts exercised in domestic and international arbitration, and also versus ad hoc and institutional rules? Do you think that the supervision has been much more in ad hoc and domestic arbitration, and when would the court really intervene?
Well, I'll share my experience both as a practicing lawyer in the international arbitration, and a member of the ICC court where I represented for India for 12 years. I think the supervision of the court is of utmost importance, and one of the reasons why London has become a center for international arbitration is because there's supervision of the court. And I recognize that I'm addressing as students, and therefore I'm going to make it more interesting with examples of how the court supervision is beneficial. When I was a member of the International Court of Arbitration of the ICC, the supervision was a very different kind. It was very rough and ready supervision. But in the English code, the supervision keeps a principle in mind that law is for justice and not justice for law. And I'm going to give you 3 examples of court supervision in 3 arbitration, all connected with India, and how important it was. And this is from my many years of experience of handling Indian cases in England. And the first was with the Steel Authority of India versus Hind Metals, where our counsel, the Indian counsel, was none other than Ashok Sen, who was a barrister, and he was Law Minister, Minister for Justice in the 3 prime ministers Pandit Nehru, Indira Gandhi, and Shastri. And he appeared with an $18 million claim, and the arbitrators found against India. But it was quite clear, because transcripts of the hearing, that there was misunderstanding and there was acrimony between Ashok Sen and David Lauterpacht QC, who was still an eminent Cambridge professor of law. Matter came to me for challenge. Mr. Sen was very, very upset about it. We challenged it, and the court set aside the award, remitted the award. And this is what the court said, and if I can just read it out to you. And the court said, however, the function of any tribunal is to separate the wheat from the chaff and to endeavor to arrive at a fair and just conclusion, notwithstanding the lack of assistance they may be getting from one or many of the party's representatives. The lack of assistance was from no other than senior counsel Ashok Sen. So the supervision of the court was useful. The award was remitted back, and the matter finished off. It never came back. The second interesting case with our supervision is Indian Oil versus Coastal Bermuda. That was also about $8 million case of the sale of oil from Nigeria. And the three eminent arbitrators, including all three Queen's Counsel, gave an award against Indian Oil. But look at the honesty of the ad hoc arbitration. Gordon Pollock QC was not Indian, he was a chairman, and he made a postscript in the, I'll just take this out. He made a postscript effectively saying that Indian Oil had lost because the Indian Oil team was incompetent. The lawyers were incompetent, and he gave them an opportunity to correct the pleadings, but he did not. And this is what the court said, setting aside the award. Mr. Justice Evans said that, let me just get my book, sorry. Yeah, the court said, I wish to record my regret that the sellers had not at some stage broadened the scope of this case. The documents give rise to a strong indication that the buyers had intended to create a clear impression in the mind of the seller that if a satisfactory settlement of demurrage claim was made, nothing further would be heard. In the result, I believe the seller had a far stronger case than they allowed themselves to advance, one of which might well have succeeded. So the arbitrators gave an award against Indian Oil, but at the same time said that if they had presented the case properly in a legal way, the result might well have been different. Parties had entered into an agreement not to appeal, which was possible in the Arbitration Act 1979. What to do? Indian Oil came to me, and their legal director said, sir, we don't mind the award going against us, but with this comment, our heads will be chopped off. Now, because of this ability to challenge the award, I took the point that on the interest of, it is against the English public policy, judicial policy, to give leave to enforce an award which is clearly not based on a true legal analysis of the evidence. That challenge was resisted, and the award was remitted. And the judge said, finality is good, but justice is better. Now, commercial arbitration, there is, of course, the need to give a quick justice, but one has to also recognize that very often the arbitrators do give out rough justice because they are not judges. So there must be some supervision. On the one hand, there's an interest of quick justice. On the other hand, there's an interest of state to ensure there is integrity in the arbitration. So there must be at least one remedy available for parties to challenge. In England, and court supervision is exercised in three ways. Under Section 67, whether there is jurisdiction, whether a contract contains an arbitration clause or not. Again, a very interesting point. And this again, in the UCOS case, after 5 years of arbitration, and I must say this because this is a very important case from Indian point of view, 5 years of arbitration, there was an award of $50 billion against Russia. Couldn't challenge, participated. Then they came to us, came to my firm, it was in Dutch, and we took the same point which I had taken for another Indian government case, PEC versus Asia Golden Rice. Now that was again, these are all reported decisions, so people can look it up and see what the argument was. Parties participated in GAFTA arbitration. PEC is a wholly owned Indian government company from Delhi, and the arbitrator decided against PEC. It was a GAFTA Grain and Feed Trade Association where lawyers were not allowed. There was an appeal, PEC lost, and they came to us. There was no hope in hell. But then we took the point that because the contract, although the contract provided for English law and English arbitration, the contract was signed on Indian soil of the Republic of India, and therefore Indian law would apply whether the contract had come into existence or not. And under Indian government rules, when a government company enters into a contract, there has to be two signatories, not necessarily of the chairman, but the chairman and the board of directors. So on the basis, we applied to challenge the award. So the whole issue was Indian law because the supervision of the court. I brought in Soli Sorabji. This is only about 5 years old, a 4 or 5 years old case. And Soli Sorabji, Attorney General of India on one side, and the other side was Harish Salve. And court accepted Soli Sorabji's award. Even though parties had participated in the arbitration, the award was set aside. Now, this all happened because of the supervision of the courts, and very legitimate point. So on the whole, I think one of the reasons why in India, the international arbitration is not taking off, because we have adopted a very strict rule of court not interfering. The way the court interferes in England is very different. The lawyers cooperate. If there's an application for leave to appeal, that is also allowed where there is an important principle of law or there is serious irregularity. An application is made on paper and the court gives leave to appeal or not to give leave to appeal, after which there is no challenge. But that challenge is very, very important, and we must always keep it. Now, what I would tell the students that international arbitration is a great opportunity. The work is going to increase all over the world because the courts are getting congested, but they must keep in mind that the most important is keeping the integrity and honesty. And this is where I think that the Indian lawyers must recognize that today in England, the way the system works, that even if the client has told me that don't say this to the court, the lawyer will somehow or the other, in a coded manner, inform the judge what is the truth. And that is the way that the lawyer is respected. And that is what we need to inculcate in India, to keep in mind that honesty and integrity is very, very important. And in arbitration, you have the freedom to take new points and new law, depending how it splits the justice. So unless there are any other questions, I think this is what I have to say to the students.
Okay, I just have one question, Sarosh, in respect of one comment you made, where you indicated that you felt that the Indian courts have approached a policy of non-interference, and it sounded as if you were suggesting that that perhaps is not the best way to go, when in fact we hear a lot of criticism from outside that Indian courts are mostly interventionist. So if you can just explain the nuances of your statement.
It's a very good point that you have made. That's because the Indian legal system, which we are following, if I may say frankly, is the colonial legal system. When British left, there were 4,500 white civil servants ruling 450 million Indians. And therefore, they had a system where they kept people, they were ruling at a distance. On that basis, the court system was also very convoluted, long pleadings, long statements. For example, in arbitration application, if an application is made, it has to be not more than 20 typed pages. The judge will throw it out if it is more than that. And you have to be straight to the point and strict internal discipline in the lawyers that they will not mislead the court. As a result, the arbitration applications are determined within a matter of days and not matter of years. But in India, unfortunately, I can say as a fellow Indian, that in India, unfortunately, the legal system is we are following is a very colonial legal system, colonial pleadings, long pleadings. I think Singapore has changed it. I think Malaysia has changed it, but we are still going on that basis. And the change must come from within the legal system, not by law. The lawyers must ensure that the judges are also educated, that they must come straight to the point. For example, if I appear in an English court, in English arbitration, and make a long-winded point, the judge will say, look, I have brain. Why are you telling me all this? Now, this is where I think the young generation must try and bring a change to bring justice into the country. Sorry if I'm just opening a new pictorial box.
Thanks, Sarosh. I'm going to move on to Sundra now. In the bid for efficiency in arbitration, how do you think expedited procedure or what we call fast track arbitration plays out? When do you feel it can best be used?
Thank you, Shaneen. Let me start off by saying that there is actually a lot of competition that is happening outside, particularly among arbitral institutions. I think also there's a lot of competition between various jurisdictions. So there is an emphasis now. Um, if you go to arbitration, it is outside the court. It's an alternative to the court. That's why it's called ADR, Alternative Dispute Resolution. The expedited procedure comes in because there is a push factor and a pull factor. The push factor is actually coming from the users. The users are saying arbitration is expensive, arbitration takes too long, arbitration is actually the Rolls Royce of justice. I mean, I don't know, because they talk like that because you can actually bring everybody there. Yeah, if you, let's say, have a ad hoc arbitration, you can actually sit for a few years and hear everybody out and finally apply all the rules of evidence or whatever it is if you want to, because there's flexibility and you can get the result that you want. And then when you get the result that you want, will be the right result, but you may not be happy because then you will go into the court system and it goes through, let's say, it's not an appeal procedure, it's a setting aside procedure. But again, that takes time. For business people, they feel that this is just too long. They can't take. They just want a decision. They say, "Give me a decision so I can carry on with my life and carry on with my business." The other side, the institutions are actually people who are providing service. And when you provide service, there's great competition to innovate. And to innovate, there is first tier, second tier, everybody, and eventually there's harmonization. For example, somebody will start off with expedited procedures. So let me start off by saying India is the only country I know where it is imposed by statute that you must finish an arbitration in 12 months, extended with another 6 months, after which you go to the courts and you ask for an extension, which can be quite dicey. So basically, that is one expedited procedure I can see straight away where it is done by statute overall. But the real procedures that you see most of the time, while parties can, by party autonomy in an ad hoc arbitration, agree to particular procedures that they want to adopt while they run it, including expedited procedures, it's rarely seen in arbitration. Let's say, you would use a general rule. You would use the UNCITRAL model, UNCITRAL arbitration rules, which has the PCA, but it doesn't administer the arbitration. So if you use ad hoc arbitration, you could have such rules being used. So there is a procedure there. But in expedited procedures, there are institutions that come out and say, I will give you a procedure that will be very exciting for you if you use it. So there are four main types of procedures that are basically coming in. The first procedure that you see is emergency arbitrator procedures. That is pre-constitution of the tribunal. Before the tribunal is constituted, instead of running off to the court to ask for interim relief, you use emergency arbitrator rules. Most probably you have to have some rules that actually govern the procedure, and you ask for the interim relief, and you will get an award, not an order. In fact, I think the old ICC rule talks about order, but you get an award. And you will find that many institutions have it, but it has to tie back to the national legislation or to to a New York Convention by the definition of what is an award. So sometimes you have to have in the national legislation that an award includes that of an emergency arbitrator. So I think this is one of the things that is required. So I think that thing is very popular now. In Singapore, I think many institutions have it, and they use it basically to put pressure to sometimes get a settlement. Because I asked for interim relief, I asked for some order that actually causes dislocation, but it can be decided because I've administered emergency arbitrator rules where the whole award comes out within 5 days. So from the appointment of the arbitrator, the hearing, and the decision, which is in a summary procedure with the relief, comes out within 5 days. It can go up to 7 days, but I think maximum most institutions is about 7 days. So it doesn't allow that. The second procedure that some institutions may offer is something that I thought was going to come out was early dismissal, or we talk about expedited formation of the arbitral tribunal itself. Two things within that. If it's an early dismissal, it could be, for example, it's like summary judgment. Summary judgment, that means there is no case to answer. So the tribunal will look at that, and there must be a rule for that. Now, the other types of expedited procedures that are now coming in, if one could be fast track arbitration. That means you have a set of rules which is similar to arbitration rules, but it is fast track. That means the time limits are breached, and normally it is a sole arbitrator, and it could be a documents only. In fact, the similarities between this type of fast track arbitration and another type of what is called expedited arbitration based on a threshold arrangement. That means if the cost, the disputed amount is $5 million or less, or 750 or less, depends on the rule, they will say that you go into the expedited procedures. So SIAC has that, ICC has that, AIAC doesn't have that. It has the fast track rules. So you may have both these kind of rules. So what happens in these rules is that first they try to simplify the procedure. They try to limit the time. They will have a sole arbitrator. Because international arbitrations, normally you will have 3 arbitrators. Parties have agreed to 3 arbitrators in the default arrangement. But because the amount is smaller, like for SIAC, they will say that the rule will apply unless the president decides otherwise. For example, in ICC is that notwithstanding contrary provision, then this expedited procedure will apply. There have been cases actually challenging it. The most important thing is that you have to look at the New York Convention. If you are doing cross-border kind of enforcement arrangements, you have to be very careful. So what can be actually enforced, let's say, in the place where you are doing the arbitration, the seat, you must be also very careful where you're going to enforce. Let's say there's a case called Noble Resources, where an SIAC arbitration expedited procedure was not recognized for overcoming, for ignoring party autonomy in having originally agreed on 3 arbitrators, then forced to come down to a single arbitrator. And although the Singapore court agreed to that. So I think these are the things that you have to see. But reality is that people want it cheaper, people want it faster, but they still want due process. They still want it to be fair. I think, if you look at all the institutions, they are having this kind of procedure. The main thing will be threshold. Second thing will be procedure. Procedure will be something that is breached, and sometimes it's only documents or a single hearing, and then highly likely it's going to be a sole arbitrator. And then you come out with an award, and the award, sometimes they even will agree for summary reasons, not full reasons. So it depends on the rules. So you have to look at the rules, and this is what is happening around the world. It is going to continue, I think, it's very, very interesting that there is so much emphasis now on speed, so much emphasis now on getting an enforceable award, so much emphasis at the same time that it should be lower cost. So again, I think the only people who will actually be very concerned about this is the users. But of course, when the users lose, they may think otherwise sometimes. I think this is where Mr. Sarosh said, that he may go to the court and go through and say, I complained that this was not fair. But once you have agreed to the procedure, you have to accept that. So I'm just talking. So one is pre-constitution of the tribunal. One is expedited formation of the tribunal. After that, the tribunal is morphs into a different creature, which is basically another tribunal, which is of sole arbitrator. The procedure changes. That means there are two sets of procedures based on the threshold. I think that's what I have to say about expedited. I'm trying to keep within the 7 minutes.
Thanks, Sundra. One very quick question. Have you participated in any fast track arbitration or documentary arbitration where you were dissatisfied with the process? And the question really is, does speed come at the cost of efficiency? Are there certain arbitrations which are more amenable to this kind of procedure than others?
I've not actually done as counsel, but I have sat as arbitrator for a number of fast track arbitrations. One under the HKIC rules, and then in Malaysia I've sat under AIAC rules at Hoc, and then even other places. But I think for me the most important thing was that as sitting as arbitrator, it is actually very good. I tell you why it's very, very good. I don't have to actually, there's very little orality. There's no more orality. Everything is actually on paper, and there is extended submissions, extended witness statements, rebuttal statements, and then there is no hearing. Everything is on document, and then you ask the questions if you have any questions. But chances are the other party will put in another set of submissions. It's just deciding when to stop it. And after that, you have everything enough. And I was quite satisfied. In fact, when I last year, I think I wrote that award as a sole arbitrator for Hong Kong International Arbitration Center. And it was actually a very large dispute. I would think would go for a normal thing. But it was because it was a shareholder dispute with development value. It could be done on paper. So it also depends on the kind of dispute. Whether you need that orality, that witnesses have to come to tell you that there is a problem with the evidence. So if the evidence is documentary in nature, there is a formula to follow, the agreement is clear. I think this falls very convenient to be resolved by fast track or even just documents only. And in certain industries, it is a lot of it is documents only. For example, I give you maritime. Very rarely, I think you do get hearings. You may get some hearings, but they may be truncated. I think that is the main complaint. In ad hoc arbitrations, is one of the things I've said in ad hoc arbitrations. I've had as many as 100 days of hearing because the parties don't want to stop. You can't stop them. That is terrible. You can go through such a thing, and it's very, very painful for the arbitrator too. Because it is prolonging over many years. So I think again, that's one of the disadvantages of not having. So maybe you go for an expedited procedure. See, one of the reactions that's happening in arbitration, particularly in construction, people are moving away from arbitration. They are now going to adjudication. They are going to adjudication because they are going for, let's say, cash flow. They say we want actually a rights-based system, temporary decision. We will actually pay and argue later. Then they go to arbitration. But some of the disputes, we notice we have that system in Malaysia where we have adjudication, which is an expedited and summary procedure, totally document, hardly any hearings. And when they come up with a decision, it is normally enforced and recognized, and people stop after that. They don't go on to. And the UK, it's also the same. In Australia, it's the same. In New Zealand, it's the same. I think these are one of the few things. This is a reaction, I'm just saying, to the attitude towards arbitration being too lengthy, too expensive, this is a reaction. But I personally, if you ask me as an arbitrator, I think if you are actually going for a normal arbitration and you get a good set of arbitrators, it's actually a Rolls Royce of dispute resolution. You get the best answer that you can get. Of course, the only right answer after that, a lot of people say is in the courts. But where facts and law is concerned, that is the best answer. You get commercial people to actually, and people highly qualified and trained.
Thank you. I like that Rolls Royce of arbitration. Sarosh, moving back to you,
Yeah.
what are the grounds that are commonly raised to challenge arbitrators, and in what kind of cases have these challenges been upheld, and when have they been rejected in your experience?
Well, again, I'm going to thank you very much. It's a pleasure to speak with you, and I'm going to speak from my own experience as a solicitor handling the challenging cases over the last 40 years in England. And we must keep in mind that England has, and London has probably 3,500 to 4,000 international arbitrations every year. And the court decides those applications very fast, often within 2 or 3 weeks. So therefore, there's a plethora of decisions and challenges in England, and many of them are decided on paper. I just want to make one comment on what Professor Rajoo said about the arbitration going for a long time. When I sit as an arbitrator, sir, and if a counsel repeats a point, I point my head and I say, I'm not crazy, I understand it. And that's the end of the repetition. And I think all of us can do that. Coming back to the English arbitration law, Section 24 allows the party to challenge the appointment of an arbitrator. Now, of course, an arbitration is a creature of contract, but it is in the interest of state to ensure that there is integrity in the arbitration. And I'll give you 3 examples. It's very difficult to challenge an appointment of arbitrator unless there are very good grounds. And I'll give you 3 examples. The first, which I handled, was many years ago, acting for China Petroleum Corporation, where an arbitrator was appointed. This is again a reported case. I can name the person, Bruce Harris, a very eminent arbitrator now. And when my firm took over from some other case, China Petroleum Corporation, and the clients found out, CNPC found out that the arbitrator was not a lawyer, but he had worked in a law firm, Richards Butler. And therefore they said, no, this is a $340 million arbitration, and we want a competent lawyer. So we challenged it. It came before Mr. Justice Mance, and we did not succeed. The court accepted that there was a possible misrepresentation. And he said that he worked as a managing, he didn't say that he was worked as a managing clerk, but he had worked with Richards Butler, and the application was dismissed. The second application which I was involved, again, which was very difficult to challenge, was about 3 or 4 years ago, again, an Indian maritime case called ASM Ship Management versus somebody whose name I cannot now recall. And in the midst of the arbitration, where the shipbroker was giving, a Greek shipbroker was giving evidence, he told the chairman of the tribunal, asked him a question, and he told the chairman of the tribunal, but why are you asking me this? You know about it, you were present. And then none of us understood what was going on. After 10 minutes of the tea break, and he came back and he said, well, I was involved for the other side some 2 years ago. And the question then came up whether we should challenge him or not. And my client wanted to challenge, but that involves cost. And the arbitration went against the Indian party, and then it was challenged. It came before the court. The court said, yes, the chairman of the tribunal, the QC, should have withdrawn immediately, but he did not. And it was a misconduct, but he refused to set aside the award on the grounds that we had not, under Section 73 of the arbitration, applied immediately for the removal of the arbitrator. And the third classic case, which became the international case and was considered the case of the year about 4 or 5 years ago on this issue, was Hashwani versus Jivaraj. Now, Hashwani versus Jivaraj concerned a Holiday Inn chain in Canada, which were purchased by 2 Ismaili Aga Khan community parties. And they came to us, and I appointed, and Mr. Hashwani, who owns all the 5 sectors, the Pearl Continental Group in Pakistan, he said, I don't want any arbitrator from my community. I want an independent arbitrator. So I appointed Sir Anthony Coleman, a retired High Court judge. The other side, Mr. Jivaraj, said, no, the arbitration clause contained the term that the arbitrator shall be a high office holder in the Aga Khan Ismaili community. So he challenged the appointment of Sir Anthony Coleman. In the first hearing before Mr. Justice Steele, we lost. In the Court of Appeal, we won. And on the basis that to have a qualification of a religion is in the breach of EU directive principle that there shall not be discrimination on the grounds of sex, religion. And we said that, look, if you allow a clause that arbitrators shall belong to a particular religion, tomorrow there might be a clause that the arbitrator shall be brown or white or a man or woman. And so the Court of Appeal unanimously decided in our favor. The matter went to Supreme Court. I'm sure all the arbitrators fraternity would know about it. And LCIA and ICC intervened on the grounds that there was this Court of Appeal judgment went against the freedom of contract. And the Supreme Court, we lost. And the Supreme Court said there is a freedom of contract. So this is a classic case of that. The matter ultimately went by complaint to the European Commission. European Commission admitted the complaint on the basis that the Supreme Court had not given effect to the EU notification on equality. But nothing happened because after that the Brexit came. So this is quite a current case. Now, it is quite common, very often the challenges to arbitrators are now coming because there's also another issue, very serious issue. Very often, the same arbitrator is appointed in several disputes involving the same legal issue. Now, what happens there? Party has a freedom of contract. Can he continue? In the past, in the maritime arbitration community, this was quite common. But there was an accepted principle that an arbitrator will be honest, and if a new argument is brought forward, even though he had decided earlier differently, he would change his mind. But in reality, I don't know whether that happens. It did happen in one case, and that also, again, Indian government case in London, a case involving, again, reported decision, Albion and Nestor. And the issue was what was the meaning of the term entry at customs at the Indian ports. There were prior entry and final entry. This was years ago when India was going to famine, lots of ships were chartered. And the arbitrators decided that it should be prior entry. Now, Indian government, Food Corporation all faced a huge liability, about $5 to $8 million for so many ships. Went before the court, Mr. Justice Bingham, he said the point which we had argued before I came on the scene were wrong. Ultimately, the same judge on a different issue, presented the point differently, decided it differently. So that was the general belief in England. But I don't know whether that now stands because the arbitration has become so competitive. And especially I find that the international arbitration has become so Americanized that it is no longer a kind of a quick decision. You have huge pleadings. I was sitting as an arbitrator between a Dutch party and as a sole arbitrator and a Chinese party. And even on the issue of damages, they brought expert opinion. And I had to literally shut them down saying that, look, I have experience to find out what is the basis of getting damages and how it's to be calculated. So the real problem is also the parties have to accept the change of circumstances. So on the issue of challenge, yes, it is possible in England to challenge the appointment of an arbitrator, but there is a freedom of contract and parties can choose the arbitrator and the court will only intervene if it is found that there is a serious evidence of corruption or dishonesty, and the court will not otherwise intervene. If there is irregularity in the way the arbitrator is conducting the process, then the requirement is that you immediately apply to the court whilst the arbitrators are sitting. Now that has a problem because there's a huge fall if you do not succeed, and it also disturbs the arbitration. So this is something which parties have to confront with removal of arbitrator, but generally it is not easy to apply for removal of arbitrator.
Thanks.
So this is my experience in practical terms.
Thank you.
The cases that I mentioned are all reported cases, and if anyone want to have a reference, they are in my book, which I have written.
Thanks. Sundra, moving back to you. What is the process of discovery in arbitration? Why is it important, and what can we do to streamline a process which is otherwise quite cumbersome?
I suppose it starts off with that the party who asserts has to prove his case. So you have to actually produce all the documents that you rely upon to prove your case. I think that's the starting point. Discovery is actually the problem of when you don't have the document and the other party is not volunteering to give that document. So I think from there you may ask for discovery. The practice now in international arbitration is not to use. I mean, of course, the Evidence Act does not apply in international arbitration, let's say in particular jurisdiction, but we have what is called the IBA rules of taking evidence. So we normally use that, and Article 3 of the IBA rules say that basically that each party can submit whatever documents that you have, and then you may, if you don't have that document, you can actually submit a request to produce to the other party to submit the document. And in that request to produce, you have to give a description of the document, of the categories of the document. And if it's e-documents, you have to identify the specifications, search terms and individuals or other menu. Then after which, you will then make a statement why it is relevant and material to the outcome. That is the test. Why it is relevant to the case and material to the outcome. So I think that is the test. After which you actually say that you don't have, you make a statement that the document is not in your possession and in custody or control, or it will not unreasonably burden the other side. And then after which you have also to state where you have some reasons to believe that the other side has these documents. And then the other side basically has two choices. It can accede to give the documents, or it will object. And when it objects, it has to state many reasons. What is its grounds for it? And some of the reasons could be there is a lack of relevance, materiality, it is a privileged document, it is unreasonable burden put on the other party to produce this document, or the document is lost or destroyed, or there's some technical or confidential considerations that I cannot produce this document because maybe some trade secrets, or there's political confidentiality. And again, you know, I think it goes back to, again, procedural economy, proportionality, fairness, equity. And then at the end of it, the arbitral tribunal has to make a decision if there's this objection. What happens in international arbitration, we have actually come out with collaborative schedules and all these things, that the techniques are very, very standard. So you may have what is called a Redfern schedule. A Redfern schedule is something basically a schedule with 4 columns where parties were invited to actually fill up. So what is the request for the document that you want? What is the purpose? And then you let's say you start out with the claimant's request, then the claimant's reason to request, what is the objection of the respondent, and then what is the reply, and then there is actually a decision by the arbitral tribunal. So this discovery will go on like that. Now, when the real issue in international arbitration, or even modern arbitration, or whatever is going on, is most of the documents nowadays are no more on paper. They are all e-documents. I think 80 to 90% is actually, in fact, this entire thing that we've been communicating is all emails. So, you know, but it is actually very normal now. It is that 90% or it's all electronic. So there is practical problems of producing those documents. So if you say that I want to actually, there are thousands and thousands and thousands of documents, and what are relevant? You know? So I think again, you know, when it comes up to that, you look at document, it has to be something in writing, it is some picture or some drawing or a program data of any kind. So basically, there is no difference between a soft copy or a hard copy. But how do you actually differentiate and cause these things? So now the modern way is the use of technology-assisted review. So in fact, even Anton Pillay thinks they are doing these kind of things where they actually look at the relevance to by search words and all these things, and eventually that comes out. So let's say the document, you finally get it, but let's say what is if the document is in the possession of a third party, the arbitral tribunal has no power to order a third party to produce it. But what can happen in most jurisdictions, you can actually subpoena the third party to come to give evidence at the arbitration hearing and bring those documents. And the third party does not actually, if the third party sometimes comes voluntarily and does not bring the document, there's nothing the arbitral tribunal can do to order production of the documents. I think the real thing that the arbitral tribunal has is to draw an adverse inference. So if the party that's supposed to give discovery or supposed to produce that document, and it is reasonably thought that you are supposed to have it, and you do not comply in doing that, the IBA rules again have 9.9.5 and 9.6 have that you can be ordered to produce the document. If you're ordered and you don't produce the document and you don't give a good reason for that, the good reason I can explain later, but then a satisfactory reason, then the arbitral tribunal will be entitled to draw an adverse inference. And a satisfactory reason could be the document is actually destroyed in accordance to company policy because you have keeping the documents only for this period, But they will actually look at the circumstances when the document is destroyed. When did the company policy come? I'm giving you an example. So these are issues that you will look at when you in international arbitration. What are the issues relating to discovery? I think quite straightforward, nothing complicated about it. We do this every day. In fact, I think this is the problem with international arbitration, where everybody is now complaining that the discovery process is becoming too prolonged, and people are asking for documents unnecessarily. So how do you deal with that again? Then you give cost orders later. So you still go through the process, but you may deal with it with cost orders. You tell them, if you ask for documents and you are unreasonable in asking for those requests, while I can draw an adverse inference, I can also give an adverse cost order even if you win. So I think this is the way we are dealing with it in international arbitration. Thank you, so Shalin.
Thank you, Sundra. Now coming to an innovation that really seems to have grabbed the legal and business fraternities by storm, and that is litigation financing. Ritin, what are your thoughts on litigation? And when I say litigation, of course, I mean arbitration as well, on third-party funding. And do you think it is something that is going to grab India by storm? Ritin, you're on mute.
He's still on mute.
Ritin, hi, are you on?
You're still on mute.
Now, sorry, okay. I think I muted myself the second time around as well. Sorry. So I was saying, I think, third-party funding still has some ways to go in India, maybe because of the legal and policy uncertainties around it, and I'll try and explain that in a couple of minutes. But just to set out exactly what third-party funding is, it's really just a third party funding a litigant or a party in arbitration in return for an agreed sum. So a party cannot bear the expenses of arbitration at the outset, and it basically agrees to take funding from a third party. That third party is obviously not doing it for charity. The third party is going to get some return on its investment or its money. And just to link in a little bit with what Mr. Rajoo also just said, I think third-party funding is important in a regime where arbitrations can be very expensive. So a party cannot simply afford to go through the whole arbitration process and await the final cost order that may come, because it simply doesn't have the wherewithal to last out that process. And that's where, the other topic he mentioned, the Malaysian Act, I know, has a very interesting provision for construction disputes, which is you can compulsorily go to an adjudicating authority for some kind of interim resolution, which at least puts the money in the hands of the party that succeeds. And then that party goes into an arbitration again. But at least in the first instance, it gets its claim amount if it's in the right. So I think third-party funding addresses that issue, which is how does a party that doesn't have funds but has a meritorious case, how is it not coerced into a settlement because of its circumstances, but can actually litigate or arbitrate that case even without having the wherewithal in the first instance. Third-party funding is interesting for me as someone who used to be a corporate lawyer, because although we're talking arbitration, third-party funding actually looks very much like an investment in a corporate transaction. So It's just that the due diligence in an M&A transaction is replaced by a due diligence of the merits of the dispute or the claim. And so I think it's quite interesting. I've been asked only once to advise on the merits of a claim in connection with somebody who wanted to fund it. And it's quite fascinating how many uncertainties there are and how many complexities there are. So I really don't know how financiers get comfortable, putting a cost to this particular investment. And that draws me, Shaneen, into the first of my few points of why I think in India it might still be a ways away, which is the significant uncertainty and unpredictability of legal outcomes, including the first element which everyone asks you is how long will this take? So if I'm investing in an arbitration, if I'm third-party funding, if I want to calculate what return I should be wanting, then obviously one of the big factors is when will I get my money back? And then the other factor, of course, is how good is this claim and should I invest in it? So I think one difficulty, at least I'm sure I would face advising somebody who wanted to invest as a third-party funder in an arbitration is I would find it difficult to give them any real comfort on what are the parameters of this investment. It's kind of like, legal advice we give even in other contexts where the client asks us what are our chances of success, how long will it take, and we're not, we're of course able to give them our best opinions, but when you consider that advice in the context of someone who needs to put his money down or her money down as a third-party funder, I think that's going to be one big challenge already for India to attract this kind of third-party funding. The second issue, maybe whether the law itself permits it. And I know the Advocates Act, and I think this is an interesting issue for students to think about that, when you're talking third-party funding, it's not just that we have to confine ourselves to the Arbitration Act. We'll look, as with any legal issue, across various subject areas. So although Shaneen's asked me about third-party funding, one is, of course, Arbitration Act. The second is questions like, can a lawyer indulge in third-party funding? And I think the Advocates Act gives us a clear answer that we cannot receive our compensation based on the success or outcome of a particular dispute. So advocates can't third-party fund. I was involved in a case called Balaji versus Bar Council of India, which was about whether foreign lawyers could practice foreign law in India. And there's a helpful submission by the Bar Council lawyer in that case, which says that third-party funding is not prohibited in India. Of course, lawyers can't do it, but third-party funding is otherwise permitted in India. So Shaneen, the second issue would be this little gray area about whether it's at all permitted. I think the other two thoughts just to leave everybody with is in the context of a party that is a foreign party wishing to do a third-party funding. What part of FEMA, of our Foreign Exchange Management Act, would this foreign funding fall under? Would it be a current account transaction or is it a lending transaction? And again, gray areas there about how you would treat this funding. And again, finally, just to bring in the disciplines that we need to think about, I've been thinking a little bit about how insolvency law will treat a foreign funding, a third-party funding transaction. Remember, third-party funding is going to happen to corporates that are not financially very strong. And so tomorrow, if that corporate goes into insolvency, but actually wins that particular arbitration claim that had been funded, what preference will that third-party funder have in insolvency? Or at the other end of the spectrum, will insolvency law even treat that as a preferential transaction or an extortionist transaction that was indulged in by the third-party funder and treated to be void? So I think, I think third-party funding is a very interesting idea, and again, it allows a meritorious litigant to be able to carry his or her litigation through its full life cycle. But I think as of right now, there still seem to be many gray areas and many things that need to be thought through before we'll see, really calculate a third-party funding. I think in an ad hoc way, many people may take some punts, but I think as a institutional thing that needs to develop, probably a lot more clarity around various concepts of it. That's my two-bit on third-party funding.
Thanks, Ritin. Thanks. I think you're right because what we've been seeing is a lot more. There have already been cases where claims or awards have been assigned. And I think for India, that is the way in which it will progress first. And of course, arbitrations which are offshore, where you're not looking at issues of repatriation and the monies can be recovered offshore. But I agree. I think it's going to be some time, but you never know. I mean, our government, when it wants to move quickly, can legislate quite fast. So if that helps us move up the World Bank rankings, you never know. We might have some regulation around that next.
Can I make a comment? Because I was involved in trying to bring third-party funding into Malaysian legislation in 2018. We did a massive legislative change to follow Untittled Model Law 2006 and with regional competitiveness. But basically, because we are sandwiched between Singapore and Hong Kong, and I was running the AIAC, so we decided that third-party funding was also the in thing because we have to compete because they have third-party funding in their place. Of course, UK, the first issue is basically lawyers have to deal with the issue of maintenance and champati. So you have to actually abolish that rule. So there was actually a big uproar because, it's very, very strange. I find the legal profession, especially outside of England, which they don't have the maintenance and champati anymore. We are more sentimental about the traditions that been handed to us. So I think, that was one thing. The other real thing, I think, which Ritin has actually pointed out, was the real problem of the transparency of money that was going to come. You see, the central bank, which is our your reserve bank, our central bank, we had to consult. They were very concerned about money laundering because they said, okay, money is coming from outside. Let's say it's not local money because we said that it is only for international arbitration. We're not going to allow domestic arbitration. We're going to start like that. Coming from outside, they said, how do we know that it is not being laundered? So that's one. So that, very simple arguments, Then the other one, I know that India is not is not part of ITSIC, doesn't do ITSIC cases. We are part of ITSIC, So we have, one of the real worries is that the high value claims that are going to come are going to be driven by third-party funding. Because an impecunious claimant who doesn't have money, of course, the other argument is access to justice, will actually use it. And then, of course, how are you going to deal with if the person cannot pay and if it loses the case, and what about the court orders? And all these things will have to be, in fact, we drafted legislation following the Singapore and Hong Kong legislation very closely. In fact, they are also struggling, trying to understand how it works. In certain countries, it's working quite well, but they don't have much. I think in the UK, it's okay. Australia doesn't have much arbitration. So I think Singapore, Hong Kong, and then we are starting to have some international arbitrations coming in. But it's meant for international arbitration. Once you allow it into the domestic market, then it will become a bit more challenging, because I think then you will have much more disciplinary cases. People will set up money lending kind of arrangements. So, so I think that it's a complex thing, because I can see the policy result. I was all for it. I was all for it. I wanted it, and I was pushing very hard. In fact, that was the only thing that they didn't allow. They allowed everything else. The government said, okay, this one we can't take it. So that's it. So I think this is something that you have to think very carefully. Because it's how you're going to regulate it. That's the main thing. And then you have to recognize the funders. Who are the third-party funders? And they are mostly Western funders. Whether you can cope with that.
All right. All right.
Mostly from America.
Yeah, go ahead, Sarosh.
I said third-party funders in England are mostly United States-based.
Yeah, there are some, I think, Australian. There is, I believe, in UK. Blue Harbour is UK. So I think there are few, but I don't see any Asian third-party funder. Do you know, Ritin, do you know anybody who's a third-party funder in Asia? Raising the capital from Asia and then incorporating in Asia.
United States company. Harbor is a United States based company.
Yes, most of them. Because they're, in the United States, the contingency fee is the way of life, isn't it? For a lawyer. So we come from a place where we cannot accept it. I think most of my colleagues cannot accept it. I said let's only open it for international. They say can't. No, this is not on. Because I think that's why I think sometimes you have to have a mindset. You got to change the mindset. But I think India is big enough. You don't have to change the mindset. You have enough work inside there.
I think there are common issues that both Malaysia and India